The defense in this case was misidentification. That was essentially the sole defense in the case, and it was a feature of the entire trial. The state, in presenting the case, elicited what essentially was hearsay testimony from a detective that, in effect, bolstered the other witness's testimony in the case and was without any exception or ground for admissibility. It was erroneous to have admitted the hearsay testimony of Detective Ruin in this case, as we framed in our issue 1 of our brief. The case was essentially a bar shooting, nighttime. The number of individuals involved was somewhat limited. There weren't a lot of witnesses for the state. What it came down to was there was an allegation of a shooting. The actual victim was not apparently the intended victim. It was like an innocent bystander who happened to be, unfortunately, in the area at the time. And the actual victim was unable to identify who shot him or any information about what type of weapon, that type of thing. So we had a couple of people who were in the area of the bar who testified for the state. And the problem with Mr. Joyner's testimony, which is the testimony that was admitted, we believe erroneously, by the court, was that, one, this gentleman was deaf. He was half blind by his own testimony, and he could not really read when he was presented documents during the trial. Couldn't read.
Couldn't read because of eyesight, or was it simply that he doesn't read well?
Well, that was never really clearly defined in the questioning. It appears that it was an eyesight issue based on a plain reading of the testimony, but it was never really clarified if that was an issue.
There's a long period here between arrest warrant and trial. It wasn't clear to me whether this man his vision had deteriorated between the time of the incident and the time of the trial, or whether it had always been the same.
Again, never really clarified during the course of the trial, but it appears that he was half blind at the time by his earlier statements, things that he said to the police back in 2007. So the inference would be that there was no evidence of any deterioration in his vision, that it was simply the way his vision was, both in 07.
He supposedly could see fine with one of his eyes.
Correct.
So if he couldn't read at trial, that would seem to me that he couldn't read as compared to he couldn't see at trial.
Which brings up a very interesting point, because as part of this bolstering that we're alleging occurred by the state in introducing this testimony was the photopack testimony. And of course the photopack was relied on heavily by the state to say this witness identified this man in a photopack. Yet how could he possibly have read the photo lineup instructions and the things that are required according to the detective when he went through the procedure if he can't read? So that again wasn't very well explored in cross-examination, but clearly was an issue that caught our attention in briefing the case. Is if he can't read, then how could he have been reading the instructions on the photopack? How could he see the photopack clearly if he has these vision issues? So all of that is why it became even more prejudicial to allow that testimony in. Anytime you have a detective who's basically now going to characterize what was said to him at the time of the offense, and the state kept using the argument contemporaneous with the offense, that kind of bolstering makes it even worse, because now you have a detective, a law enforcement official, who is basically vouching for, well, here's what he said at the time, and this is when it happened, and clearly this is going to be better testimony than what he's saying now because he's confused. And with all due respect to the state in their answer, they said, well, it's merely conjecture that that this was admitted for the purpose of bolstering. There's no real evidence of that, and I would simply point to the prosecutor's closing argument. He made that a feature. He specifically said in his closing that that was indeed important, that this gentleman had said this, that it was consistent with the other witnesses' testimony. So it had the effect of basically boosting the evidence in the case. When we're dealing with identification issues, which the court's well aware, identification is probably the worst form of evidence. And when you're dealing with a situation with a bar shooting at night, all of these individuals hanging out in front of this bar, it's not a great case for the state in the best of circumstances. But when you have an individual who has given one story purportedly at the time of when the incident occurred, then gives another story in deposition as to the description of this person, then comes in trial and gives still yet another description of the individual, and then that's an attempt is made to correct all of those inconsistencies by saying, well, let's go back to the very beginning when you gave this initial statement. This is what you said. This is what's consistent with what the other witnesses said. We believe that that should be fatal to the state's case, to be able to do that, to allow that testimony in under these circumstances, highly prejudicial. And there was no analysis conducted by the trial court. This was a situation where defense counsel made his objection. We dispute that it wasn't a specific objection. It was specific enough to put the court on notice that the court knew this was a hearsay objection. And the court immediately took the matter without any argument or really input by the state and discussed it on the record and said, well, this is for impeachment or for recent fabrication, as the record shows, and then allowed that testimony in. There was no balancing test. There was no discussion of what prejudicial effect that might have. There was no discussion.
Anybody asked for that, though? I mean, this is the judge who's watching the witness, whether this is impeachment that's appropriate is something you can see better than we can see.
I think that in the best of worlds, yes, those things should have been brought out in further discussion, but I think there was enough there, certainly, to preserve the matter for your review. And it's unfortunate that...
I don't disagree with you about the preservation. The judge took it. The judge did 3/4 of the argument in his own mind before it ever got started. He knew what your objection was, and so that it's clearly preserved. It's just why isn't he correct that it could be admissible as impeachment?
Well, it's not admissible as impeachment because there's no real... First of all, there was no nothing established that this was a surprise to the state. There was none of the prerequisites at all were laid out for essentially laying the foundation for impeachment. It just jumped right into, let's introduce now what he said to the detective back in 2007. It's clearly not impeachment because when it's argued by the state in closing argument, it's utilized for the very purpose, the explicit purpose of bolstering. And that's why it's so clear what the state's purpose was, as evidenced by their own closing argument. We would say that in totality, that should never have come in. And the second issue deals with not allowing counsel to have a continuance for preparation for trial. We rely on the brief and the issues and the issue contained in there with respect to that argument.
Thank you, Mr. Chairman.
Thank you.
May it please the court, good morning. My name is Donna Koch. I'm here today on behalf of the state of Florida. The trial court made the correct ruling in this case when he allowed impeachment by Detective Rulon to Mr. Joyner's trial testimony. This evidence was clearly incorrectly admitted under 90.608. During trial, Mr. Joyner, during his testimony, began to testify differently than he had in his police statement. So what the state initially attempted to do is hand Mr. Joyner his prior police statement and asked him to please take a look at it. But Mr. Joyner said, I cannot read. And so the state now is left with a situation where she can't refresh his recollection, but she continues and asks him a few more questions in dealing with the description of the shooter. And he testifies differently. He says that the shooter had long sideburns and he had regular kind of hair. So what then happens is when Detective Rulon comes up for his trial testimony, and by the way, he was the investigating officer and he testified to many important factors other than this testimony. The state then asked him if he had taken a statement, and he said yes, and then the state then asked him if, over the objection which was allowed, about the prior description, and he said yes. A couple of days, we don't even know how quickly that statement was given. It may have been taken on the night of it, but clearly by the next day, the statement was taken that yes, the shooter had small twists and he was clean shaven. That was shown specifically as impeachment of the prior testimony.
The witness didn't need to be able to read his prior statement in order for it to be used as impeachment. He'd only need to read it for recollection refresh, right?
Right, yes. And
I don't understand why the state didn't impeach. If they were going to impeach this man, why didn't they do it while he was on the stand?
Well,
Isn't it true 6 years ago this is the statement you gave to the
Well,
officer?
she did. She did, in essence. She said, do you remember testifying that, he was clean shaven? He goes, no. He had short sideburns. She goes, well, do you remember, saying, yes.
Before this part.
Yes, that's correct. And one thing I wanted to really clear up about counsel's argument, he's saying that it's very clear that the state was using this evidence as substantive evidence, as hearsay evidence, but that's not clear at all, because what happened in closing argument? The state, in its initial closing argument, does not mention that testimony at all. It does not mention that there was Detective Rulon came in and showed how there was inconsistent testimony. It was not used as substantive evidence. What then happens is defense counsel, inconsistent with trying to establish that there was, misidentification, he comes in and points out to every single inconsistency in every witness's testimony. And that was really his sole argument, is to point out the inconsistencies. And then what he says, of course, is that there's reasonable doubt here, because look at all these inconsistencies. So then the state, in rebuttal, gets up, and his fair reply comes in and then talks about, and that's the statement quoted in the reply brief, it's rebuttal argument. So it was not used as substantive evidence to prove that the descriptions were all consistent. It wasn't until rebuttal argument that it came out that they were inconsistent. And that was clearly fair reply in this case to the closing argument of defense counsel, which was very strong. I also want to point out that the primary and most important witness was David Baker. Mr. Baker was the intended victim. He had a 15 to 20 minute face-to-face argument with the shooter, the appellant, before the shooter leaves and then comes back. And then he testifies that he sees the same gentleman come back. They didn't know each other. And then he actually sees the shooter approach him. It's the same gentleman. He sees him approach him, lift up his arm, and while he doesn't specifically see a gun in his hand, he thought he was going to be hit, so he moves to the side, and immediately the gentleman behind him gets shot. There was only one shot that night, one shooter. So David Baker, the intended victim, is the most important eyewitness here. But then we also have two other witnesses who are significant, more so than Mr. Joyner, one could argue. One was the aunt of the appellant, was there during that initial altercation, verbal altercation between the appellant and David Baker. And she actually, at the time of trial, she was blind. However, so she couldn't make an in-court identification. However, she could see in 2007. But what's important and significant, 4 days for Mrs. Walker, she picks the appellant out of a photo pack. 3 days after the shooting, Mr. Joyner picks the appellant out of the photo pack, and again 4 days later, Mr. Baker. So 3 witnesses have picked out the appellant from the photo pack within days of the shooting, that he was indeed the shooter. Then we also have another witness, Mrs. Williams, who was down the street 100 yards from the Blue Chip bar that night, and she actually sees a gentleman in his car get out of his car, pace around, act really suspicious and strange. She walks back over to her house, and he says to her, "I wouldn't walk down to the Blue Chip bar," and and she says, "I'm just going to go close my door." And so then she actually sees this gentleman get a gun out of his trunk, get back in his car, drive down to the Blue Chip bar, and shoot. So that was the one shot. So we actually have many witnesses here that point to the appellant as the shooter. So what looks like could have happened with this jury as far as Mr. Joyner, and this trial judge allowed the jury to ask questions. Well, after Mr. Joyner's trial testimony, it was so confusing. This jury actually asked 6 different questions to clear up the testimony of Mr. Joyner in their mind. And Mr. Joyner's answers were still very confusing. So an excellent argument should be able to be made that ultimately the jury's probably not going to give a lot of weight to Mr. Joyner's testimony anyway. He said he could see, but then he couldn't see. So ultimately, any error in the admission, and clearly it was properly admitted under 90.608, it would have been harmless in any case. Apparently there's no additional evidence being offered on the second issue, so the state would also stand on its brief in this matter, and we would ask this court to please affirm. Thank you.
Thank you, Ms. Coe. Mr. Trevano.
I would respond briefly that the idea that this was somehow just rebuttal and permissible is erroneous, because it was used as substantive evidence. It indeed was. It was argued as substantive evidence, and whether it was during the first closing argument or the state's second closing argument, it was still presented to the jury as substantive evidence. And again, when you have a police detective who is going to summarize what was said to him and what was written to him back in 2007, what was told to him, and what he documented in his report, it's bolstering. And there's just simply no way around that. It's improper. And in this case, I would respectfully disagree with the state that that there are other witnesses, other evidence, harmless error. This was a very close case. The witnesses were inconsistent amongst themselves as to how many occupants were in the vehicle, whether he's on foot, he drove over there, what he looks like. There was a tattoo mentioned frequently in the testimony, whereas the defendant, the appellant in the case, had no tattoo. So there were a lot of things that were suggestive of a possible misidentification. And when you have a close case like that, supported by improper bolstering, that's what makes it even more egregious. So we would respectfully suggest that the case should be reversed and remanded. Okay. Thank you.
All right. Now we're going to...
Arnold Schwarzenegger out of the dock.
You'll be back. Okay. State versus Garwacki and O'Connell. Just have a little electric sound. Yeah, fan it.